Hi, this is Joe Dragon, and this is Dragon Law Group's video blog. The purpose of today's video is to provide information on child custody in Nevada. This is not legal advice, nor is anything else that you find on dragonlawgroup.com. It's meant for educational purposes only. Please seek an attorney if you have for your specific legal needs. So, child custody in Nevada. This video gives an overview of the three categories that a court considers before awarding child custody, and that's primary custody, primary physical custody, joint physical custody, and three visitation rights. There's also a category called legal custody, which has nothing to do with physical custody, and I'll explain that at the end. Okay, so if you have started a divorce, filed for divorce, are in the middle of divorce, or need to change a child custody arrangement, it's good to know what these three categories actually mean legally. We all have a general idea of what they mean, but let me explain in legal terms. So the first category, which is joint physical custody. What that means is both parents are responsible, both parents have joint physical custody over the children, and that's determined by the amount of time a child spends with each parent in a given year. If one parent has physical custody of the child between 40% and 60% of the time, and the other parent has the opposite of that, then you're in a joint physical custody arrangement. It's not always 40% or 60% as the CAPers say, but that's generally a safe assumption if you're trying to figure out the arrangement. To understand kind of how the law treats custody arrangements, a basic understanding of parental rights is needed. So in Nevada and in every state in the country, both parents have a legal obligation to care for their children until they reach the age of majority of 18 or 19 if they are still in high school, at least in Nevada. So these requirements include they're basic. The parents have to feed their children, have to clothe their children, and have to provide shelter for the children, in addition to education, which is of course mandated by law. Other than that, there's no specific requirement. I mean, everything else falls into what I call parenting decisions. You know, which school you think the child should go to, or what activities is good for the child. Those sorts of things, the law has nothing to do with. It's just up to the parents to provide those four basic needs and medical when appropriate for their children. Okay, so as I said earlier, joint physical custody, if you have the child between 40 or 60% of the time, you will have primary custody. You guessed it, if you have the child around 60% or more of the time in any given year. Why is there a distinction between joint physical and primary custody? It has to do with child support. So if you're in a situation where one parent has primary physical custody, the other parent must pay that parent child support. And there's a different video and blog on how you actually calculate that. It's fairly simple to the other parent. Because of this, many parents are in disagreement on whether to arrange a joint physical custody, primary custody, or with visitation because of the obligation to pay. I would say it's not very appropriate reason to consider child custody arrangement, because either way, you may financially have to support your children. For instance, if you have primary custody and therefore avoiding the child support obligation during that time, you also obviously have the children much more than the other spouse, meaning much more of your time is obligated to taking care of them. If you work full time as a single parent, you know that it can be difficult as far as your schedule goes. I've seen parents before who hire a nanny while they're at work so they can have primary physical custody. Well, nannies are usually more expensive unless you find a good one that doesn't charge too much than actually paying child support. So these kind of considerations need to go into what what a child custody arrangement for your case might look like. Not simply the fact that you may have to pay child support, because you have to do that regardless. If you're in a joint physical custody arrangement, the child support obligation still exists. And that works by whichever parent at that point receives more income will have an obligation to the other parent despite having joint physical custody. And that's calculated by figuring out both of the parents' obligations if they didn't have joint physical custody, and then subtracting the greater from the lesser. So in a joint physical custody arrangement, the parent who has greater income will still pay child support. And then the last is visitation rights. That happens when you do not enjoy either joint or primary physical custody. And the court, how this works, sets, certain weekends, periods of time where you will see the children. Now, I believe there is kind of a stigma that goes into this in society. I think a lot of times parents want either joint physical or primary custody because of the stigma that if they don't, then they kind of look at themselves as a bad parent. I will say that's nothing further from the truth. If you have visitation 2-3 weekends a month and you're working during the week, that is completely appropriate and does not mean you're a bad parent. You're taking care of the finances for the kids during the time you don't see them, and you get to spend a lot of quality time. If you work 10 hours a day and you don't see your children much anyhow, there really is no difference between just having visitation. So kind of going over when the court, as I said, assumes that joint physical custody is probably in the best interest of the children. What gets in the way with that? A lot of times, if you don't live in the same city or state, obviously, passing the kids off 1 week on, 1 week off, something like that isn't really feasible. And so you need to get into a different type of arrangement. If you live in the same city and you live relatively close, then there's all types of options you can do for joint physical custody. You can do 1 week on, 1 week off, 2 weeks on, 2 weeks off. In my experience, though, children do like stable environments. So going back and forth every week probably isn't in their best interest. It just interrupts the routine, and you could see issues in school for those types of arrangements. Another good option would be to, if you don't live in separate cities, or you really even live in the same city, is a lot of times parents will have the kids for the school year, and the other parent will have them during summer break, or maybe a month in winter as well. Okay, so those are the three categories. The last thing to consider too is just holiday schedules. Of course, you have the big ones: Thanksgiving, Christmas. They put 4th of July in there, and obviously these are very family intense holidays. So the best advice I can give as far as setting up a holiday schedule is simply do it 1 year on, 1 year off, and flip Thanksgiving and Christmas. So you have the kids for Thanksgiving 1 year, the other year you won't when you have Christmas. It really is the probably the best solution to that situation. If you're on good terms with your ex-spouse, then by all means share Christmases together if that's feasible. And parents do that, and I have seen it, and that is probably the ultimate solution, but I understand it's not feasible for everybody. The last category is kind of the subcategory is legal custody. And what this means is that who has legal custody makes the kind of life decisions for the child, what doctors they see, what schools they go to, what religion they participate in. Now, 90% or more of the time, a court is simply going to award joint legal custody. Unless there's a very good reason that one parent's not competent, it's going to be joint legal custody. And by a very good reason, I mean someone who just really isn't mentally competent to make those types of decisions. You may disagree on what religion the children should be a part of. That's not a good reason. You can't go to court and say, I believe this religion, or like, so I get to make the decision because I'm right and it's a better religion or something like that. Judges simply won't entertain those types of arguments. So that's legal custody is very most likely going to be joint legal custody. Okay. How do you determine necessarily if you can't agree on which one of the categories the kids should be a part of? Well, the courts are going to look at one thing to consider, and that is what is in the best interest of the children. So if you live in a neighborhood, for instance, that has a better school, perhaps the judge will definitely take that into consideration when making a custody arrangement, because if it's a better school, then the child is likely to do better in life, and so that's in the best interest of the child. Remember that there's a difference between what the law determines in the best interest and what you think is in the best interest. Not saying you're wrong, but the law only looks at certain things. It's not, like I said, I've used the religious example, or perhaps, maybe you think it's really good for your kid to participate in some sort of sport, and the parent doesn't think so. Those are parenting decisions, and the court's just not going to get involved. So best interest are concrete things, school, neighborhoods, these types of things, not parenting decisions. Okay, well, I hope you found that video helpful. If you have any questions, feel free to contact us here at dragonlawgroup.com. You can email me directly, and my number is, my email is jdragon@dragonlawgroup.com. Thank you very much.